Okay, committee, I'm going to go ahead and call the meeting to order. Thank you. Stephanie, or Representative Clayton has an announcement.
Well, I think a lot of us, it's spring break, so it's always a fun time in the legislature. Lots of kids coming here with their parents for work, welcoming my son Eli, who is a sixth grader at John Deemer Elementary. And I know Representative Auerkamp has his family with him as well. It's a good looking family. I think they've already left, but there you go.
Thank you, Representative. And welcome Eli to Commerce Committee. Committee, the first item on the agenda and the only item on the agenda is a hearing on SB 150. We're going to go ahead and open that, and I want to apologize in advance. We're not quite as organized as we should be because Dennis canceled our meeting last week. we had to all the conferees had to kind of bounce back and forth, so some of them that were going to be here in person are now online, and we're just going to try to get through it. With that, I will start with a description on what SB 150 does, and that would be Charles Reimer, Reviser Reimer.
Thank you, Chairman, members of the committee. Senate Bill 150 would regulate legal advertisements and also regulate protected medical information in the context of legal advertising. So first of all, if you turn to page 2 of the bill, there's a definition of legal advertisement. Means a solicitation for legal services other than legal services performed by a bona fide nonprofit provider of pro bono legal services through television, radio, internet, newspaper, other periodical, outdoor display, or any other written, electronic, or recorded communication. The bill would require a couple of things and prohibit things. One is that it would require that the identity of the sponsor of the advertisement be disclosed. It would also require that a disclosure that this is a paid advertisement for legal services be made at the outset of the advertisement. It would require that the identity of the attorney or law firm that will represent clients be indicated, and also how cases would be referred to attorneys or law firms that would represent clients if the sponsor of the advertisement may not represent individuals responding to the advertisement. The bill also prohibits some things. A legal advertisement is not to be presented as a medical alert, a health alert, a consumer alert, a public service announcement, or similar terms like that. A legal advertisement is not to display the logo of a federal or state governmental agency in a manner that would suggest affiliation with that agency. A legal advertisement is not to use the word recall when referring to a product that has not been recalled by a governmental agency. With respect to clients who may have been injured from a prescription drug or from a prescription drug or medical device, the legal advertisement is to include the warning, do not stop taking a prescribed medication without first consulting with your doctor. Discontinuing a prescribed medication without your doctor's advice can result in injury. So that is a requirement with respect to an advertisement when the advertisement is soliciting clients who may allege an injury from a prescription drug. With respect to a solicitation for clients who may allege an injury resulting from a prescription drug or medical device, the bill would require that a disclosure be made that if in fact the medical device or drug is approved by the FDA, that the Federal Food and Drug Administration continues to approve that particular drug or medical device unless the product actually has been recalled or withdrawn. There are some provisions pertaining to clarification, making sure that a legal advertisement is clear. That's on page 2 of the bill and the bottom of page 1. An advertisement is to be presented clearly and conspicuously. Written disclosures are to be clearly legible. If televised, they're to be displayed electronically. They're supposed to be on the screen for a sufficient time to enable the viewer to easily see and fully read them. Spoken disclosures are to be plainly audible and clearly intelligible. With respect to enforcement of this bill, any violations of Section 1 constitute an unlawful and deceptive trade practice under the Consumer Protection Act, and they are subject to the penalties of the Consumer Protection Act, which is a civil fine of up to $10,000. The second one more item of note is that if you look at subsection E, lines 20 through 22 on the second page, there's language that specifies that the bill is not to be construed to limit or otherwise affect the authority of the Kansas Supreme Court with respect to regulation of attorneys. Section 2 pertains to protected health information, and the protected health information we're talking about in Section 2 is basically protected information under HIPAA. Section 2 prohibits a person from using, causing to be used, obtaining, selling, transferring, or disclosing to another person without written authorization protected health information for the purpose of soliciting an individual for legal services. Again, as far as enforcement goes, this is an unlawful and deceptive trade practice under the Consumer Protection Act. The penalties provided for under that act would apply. In addition, there's a criminal penalty involved with respect to Section 2, and that is a violation would be a Class A non-person misdemeanor. And finally, again, we have that provision that, nothing in the Section 2 is to limit or otherwise affect the authority of the Kansas Supreme Court to regulate the practice of law or enforce its rules. In addition, nothing should be construed to apply to the use or disclosure of protected health information to an individual's legal representative in the course of any judicial administrative proceeding. And if enacted, this bill would become effective July 1st, 2022.
Thank you, Charles. Any questions? Representative Hoffman?
Thank you, Mr. Chairman. I just want to clarify, this is all new language, right?
It is.
Okay.
Representative Dodson?
Just a couple of quick questions. The national advertising that comes down to stations around the state of Kansas, those organizations that operate in Kansas are responsible for looking at the advertisements?
So I'd have to look into that a little bit with respect to jurisdiction, but under the Supreme Court rules, of course, a Kansas licensed attorney would be responsible for their advertisements. Under this provision, it's a person engaging in legal advertisement within this state. So there has to be some kind of nexus with the state, but if it's a national firm, if there's some tie with an attorney within the state, then that would be the avenue to regulate.
The other one that we find particularly up in the northeast part of Kansas here is that Missouri stations are heard in Kansas. Same might be true of Oklahoma. So do we have some jurisdiction there?
That's a good question. So I think since enforcement is either, by the Attorney General or a district attorney or a county attorney or an aggrieved consumer, that I guess would be an issue of jurisdiction, determined by the enforcing entity, by the court. the bill does not really speak to that. It just says within this state. So, other provisions of law would have to kind of come into play to figure out whether one could enforce it against a radio station out of state.
Thanks very much. Thanks, Mr. Chair.
Or I mean, against an attorney who is advertising on a radio station out of state.
Representative Ralph.
Thank you, Mr. Chair. Chuck, I've got some concerns in several spots, but specifically talking about Section 2 and the protected health information right off. And I guess this is just kind of a precursor to any proponents that I've got some concerns about the protected health information references in here. But from what I see, protected health information is a defined concept or term under HIPAA. And our statute here simply uses the definition under HIPAA when we talk about protected health information. Am I understanding that right?
Yep.
So we would then acknowledge under this that if I tell you that I have appendicitis and I tell my doctor I have appendicitis, when I tell it to my doctor, that's protected health information as defined under HIPAA. But if I tell you I have appendicitis, it's the same information, but it's not protected health information. That's generally how that works. So in this instance, I'm having a hard time, and maybe you'll defer to the proponents. I'm having a hard time understanding why we're talking about in Section 2 that you can't disclose protected health information, where it appears that we're trying to talk about somebody besides the healthcare providers themselves. And I pretty much expect you to defer that to the proponents at this point.
Yeah, and I think that's a good plan. I would just, I would just, point out that, kind of the nutshell of Section 2 there is in that first subsection A. And so we need written authorization, right? And it's for the purpose of soliciting. So I guess there is sort of a, kind of a context there, but I will defer to them.
Thank you. Thank you, Mr. Chair.
We still have another question. I'm sorry, Charles. Representative Clayton.
Thank you. Just offering points of clarification as far as this legislation. When it comes to drugs or medical devices that are still currently approved by the FDA, is that saying that that doesn't apply here? Because I know that there are some that are still currently approved by the FDA that have had lawsuits against them and have caused problems. And I've heard advertising regarding that. So can you clarify that point a little bit more for me, please?
Yeah, certainly, Representative. So the two provisions of the bill that really go toward your question are paragraphs 7 and 8 on the bottom of page 1, lines 24 through the end of the page there. And so basically, if you're trying to solicit a client who may allege an injury because of a drug, and the drug is approved by the FDA, then you have to include a specified warning, which is do not stop taking a prescribed medication, as I had indicated before. So you got to have that warning in your advertisement that you're not supposed to stop. You shouldn't discontinue the medication without speaking with your doctor. Paragraph 8 is a little bit broader. It goes to either soliciting a client who might be injured from a prescription drug or a medical device. And they are approved. If they are approved by the FDA, then you have to disclose that the drug or medical device remains approved by the FDA, unless in fact it actually has been recalled or withdrawn. So those are the two provisions that go directly to your question.
Thank you. And committee, I would ask you to Google any sorts of lawsuits regarding Paragard, which is an IUD that is still currently approved by the FDA, but has caused a lot of medical problems. Thank you, Charles. Thank you, Mr. Chair.
Okay, seeing no further questions for you, sir. Thank you very much. We'll move on to the proponent section. And we're going to start with Eric Stafford, the Kansas Chamber.
Thank you, Mr. Chairman and committee members. Good afternoon. Eric Stafford with the Kansas Chamber here in support of Senate Bill 150. Appreciate Chuck doing a good job summarizing this bill that did just recently pass the Senate. Basically, what we have here today is a policy item that we sought out from the Institute of Legal Reform. We've seen our overall legal climate ranking slip pretty dramatically. We used to be top 10 back in the late 2000s and early 2010s, but we've recently dropped to mid 30s, roughly low to mid 30s in the Institute for Legal Reform survey that they do every 2 years on state legal climates. But what prompted us to, that's basically what prompted us to start looking at policies that we can pursue at the state level to help strengthen our legal climate for the issues that we can control. Some of those items that we can't control is our Supreme Court eliminating caps on non-economic damages for non-medical malpractice cases. It's currently going through the process to see if that decision applies to medical malpractice, and we'll wait to see what happens there before we determine what's next. There's several factors that they look at, but ultimately, as we've been doing some digging, what can be done? This was one of those items. We have another bill over on the Senate side as well that we had introduced. But for focus for today, Senate Bill 150 is basically a bill that provides consumer protection, places under the Consumer Protection Act, misleading or deceptive advertising, legal advertising practices. And there's some examples of what is a good ad that would comply with Senate Bill 150 and what it would be a ad that does not comply with Senate Bill 150 through the PDF copy of our testimony. You can click the link and view those. Basically, these advertisements that are out there, sometimes by national firms, largely by national firms, but they're client phishing, and that's where we'll get into section 2 of the bill and the purpose behind that. Also, a representative from ILR will be testifying. Carrie Silverman is scheduled to testify today as well. But there are hundreds of millions of dollars of spent on advertisements, some of them for legitimate reasons, some of them, again, just kind of searching to see if something could stick. And this is an attempt to try and provide those protections to Kansans who might see these advertisements and be influenced to take proactive measures on their own without consulting with the physician that could lead to personal injury. For your guys' background, this law has been passed. I think it's Texas, Indiana, Tennessee, and West Virginia. And West Virginia is currently being challenged. Just last week, actually, I listened to it yesterday, the audio recording of the Court of Appeals. So district court ruled that it violated First Amendment freedom of speech. Court of Appeals arguments last week seemed pretty favorable based on the line of questions from the judges. That is this really restricting? We have all these disclosure requirements of pharmaceutical companies to say you have a risk of whatever in whatever drug it is that they're advertising. But at the same time, we can't prevent firms from avoiding the use of the word recall when there hasn't been a recall. Some other provisions in the bill, you can't use the logo of a federal or state agency. We don't want to give the impression that this is a government-endorsed message. Again, if there hasn't been any action by the Food and Drug Administration to take proactive steps because something is harmful. In our written comments, you'll see a paragraph, I think it's the 4th paragraph, on Pradaxa and how this actually goes into effect when implemented, and how these plaintiffs' lawyers kind of take proactive measures to earn awards for individuals. So basically, it was announced by the FDA that they were going to research reports of increased risks of bleeding from this medication. FDA never took any action against Pradaxa, never found that there was any higher risk of bleeding than any other medications that were out there. But 4,000 cases were filed, and then there was a $650 million settlement for a drug that has no increased known side effects because of efforts by plaintiffs' firms to pursue these claims with or without merit. But it's forcing businesses into settlements. Second section I want to talk about of the bill. So the first section is focusing on the what to do or what not to do in the actual advertisement. Section 2 of the bill, to Representative Ralph's questions of what kind of the purpose is here and protected health information. Basically, some of these advertisements that you see on television, they're not by actual law firms. They're by data collection firms who collect consumer data and then sell that data to law firms so they can then have a potential list of clients. So we're not banning that practice. We're not saying you can't do it, but you just need written authorization. If you're going to provide protected health information of that individual that you're collecting data on to sell to a law firm, you need their written authorization in order to do so. So that is the purpose of Section 2 of the bill, as it all kind of ties into the content here. So, Mr. Chairman, that would conclude our testimony. I'm happy to answer any questions at the appropriate time. And then, as I mentioned, Kerry from the Institute for Legal Reform will be giving his testimony as well at some point. But whenever's appropriate, happy to answer questions.
Okay, let's go ahead and get through all the proponents before we ask questions. Thanks. Next up, we have Kerry Silverman for the U.S. Chamber Institute for Legal Reform. I understand he's virtual.
Hi, Mr. Chairman. Can you hear me okay?
We can. Thank you.
Okay, great. Thank you, Mr. Chairman and members of the committee. I appreciate the opportunity to testify today in support of SB 150 and do so virtually on behalf of the U.S. Chamber Institute for Legal Reform. I'm an attorney at Shook, Hardy & Bacon, where I've practiced for over 20 years, and I've closely studied and written about lawsuit advertising practices. By now, you all have likely experienced the constant daytime and late night advertisements for legal services. And if you've watched them as closely as I have, you'll notice that when they target products such as medications or medical devices or sometimes consumer products, they often follow the same script. They begin with a dramatic voiceover and official sounding language declaring a medical alert. Some are framed as public service announcements or news reports, suggesting the ad will provide impartial health information to the viewers. Some might be just called a helpline. And after getting the viewer's attention, the ad then lists a range of serious illnesses or medical conditions that it's attributed to the product. Those risks, they might be contrary to science, they might be extraordinarily low, or they may be fully understood by regulators and doctors. Sometimes the official logo of the FDA will flash in the background as the announcer tells viewers that the safety of the product is being investigated or that lawsuits against the manufacturer have been filed. And the ads often conclude by telling viewers that if you or a loved one have experienced, used the product, call right now because you may be entitled to substantial compensation. And the final screen of the ad that flashes is usually a full page of unreadable fine print, and tucked in that fine print may be the identity of the firm or the entity that is sponsoring the advertisement buried in there. And you'll see similar tactics used online, where websites with photos of doctors suggest that they offer unbiased health information on recalled or dangerous products when they are thinly disguised lawsuit referral services. And the goal of these ads, whether they're online or whether they're on TV or on social media, is to generate as many what they call leads for lawsuits as possible to fuel mass tort litigation. And it's ultimately to pressure businesses to settle cases even if the scientific consensus is that the product is safe and beneficial. And when these types of practices are left unconstrained, they could have real serious side effects for the public. These aren't hypothetical concerns. There's been real documented consequences for viewers in scientific journals, and it's cited. I've submitted written testimony with probably about a dozen studies that have found backing up the types of injuries that have occurred and misleading of consumers that has occurred because of these types of ads. Mr. Stafford mentioned earlier the Xarelto ads, and you may remember seeing those ads a few years ago. Plaintiffs' lawyers spent over $100 million on those ads alone in a couple of years. They were typically presented as Xarelto alerts, Xarelto warnings, or as starting with an important medical announcement. These types of misleading commercials would repeatedly tell patients, many of whom were old and sick, that the blood thinner that was prescribed by their doctor to prevent a stroke would actually kill them. And in 2019, FDA researchers, not tort reform advocates, but people at the agency, searched the agency's adverse event reporting system, and they found 66 reports of patients who discontinued a blood thinning medication after reviewing a lawsuit ad. Half of these patients experienced a stroke, 7 of them died, 24 experienced other serious injuries, and as I mentioned, most of these were senior citizens. Doctors also gave disturbing firsthand accounts of patients who had died, experienced serious injuries, or placed themselves at considerable risk because they stopped taking their blood thinning medication after viewing a misleading lawsuit ad. But the concerns don't just involve blood thinners. There have been surveys of patients and doctors have shown similar reactions to lawsuits targeting mental health conditions, drugs that treat mental health conditions, to diabetes. And another consequence that we're seeing of misleading lawsuit ads is that viewers are discouraged from seeking treatment that they need and that will benefit them. Just last year was in the news a study of 1,500 at-risk youth and young adults who are candidates for HIV prevention medications. The study found that half of the population, at-risk population, had seen the lawsuit ads, mostly on social media, asserting that the use of the drugs could cause kidney or bone injuries. And 1 in 5 of those people who had seen those ads decided to stop using or not to use the medication as a result. And the ads led to an outcry by advocacy groups for at-risk patients who blamed the ads for causing a public health crisis. Finally, many viewers of the lawsuit ads are misled to believe that a product in the ad has been recalled, when it's simply not true. We saw this online on websites called things like MedRecall News and others that would use the term recall and contain lengthy drop-down lists of drugs, medical devices, or other products, which would mix in many products that had never been recalled ever. Websites or ads referring to medications that had been approved by the FDA as bad drugs are also likely to confuse reasonable viewers, particularly those who might be sick. Now, this type of recall confusion has also been documented in the medical literature. One study, for example, found that more than half of new patients who went to a urology clinic for treatment mistakenly believe that there was a recall of pelvic mesh devices that would be used to treat their condition due to the lawsuit ads. It's not just the civil justice community that's calling for reform here. It's the medical community that has as well. In 2016, the American Medical Association passed a resolution asking legislatures to address this issue. And since then, they've found that these types of practices have become, in their words, even more pervasive. And that's exactly what SB 150 is there to do. And Mr. Reamer explained the provisions of the bill, and they narrowly target the types of specific deceptive practices that we're discussing today that are commonly used in lawsuit ads and that have been proven to mislead consumers and to hurt the public. And there are going to be those who favor unrestricted lawsuit advertising who are going to contend that this bill violates the First Amendment. And yes, attorney advertising is commercial speech that is protected by the First Amendment. But just as with any other product or service, the First Amendment doesn't protect false or misleading advertising. It protects truthful advertising. We're talking here about deceptive practices or some practices that are just outright false. There's no constitutional exemption for attorneys or for lead generators from what are really ordinary consumer protections. And legislators should step in when misleading lawsuit ads jeopardize public health. And finally, just to conclude, I think it's important to recognize that the provisions of SB 150 aren't going to stop lawsuit ads or make them more difficult to run. There's many attorney ads out there right now that have none of the practices addressed by this bill. And for those that do, as Mr. Stafford noted, 4 states have already enacted legislation similar to this. And what we've seen, and what I've seen in watching lawsuit ads, is that the lead generating companies that run them nationally are responding to those types of laws. We're seeing fewer ads that begin with "this is a medical alert" and more ads stating "this is a legal alert." We're seeing fewer ads that misuse the FDA logo. We're seeing more ads caution viewers that they shouldn't stop taking a prescribed medication before they speak with their doctor. And those ads, they haven't stopped mass tort litigation advertising. It's just that deceptive practices are becoming less common. And so for those reasons, we support the enactment of SB 150, and I'd take your questions whenever appropriate. Thank you.
Okay, thank you, sir. And let's see, is there anyone else here that wishes to testify as a proponent in person or online? I see that we do have some written testimony that was also sent in, and we'll go ahead and open questions for the proponents. And if anyone has a question for Mr. Silverman directly, make sure you state so. And Dennis, if you would keep an eye online to find out if he has something to say in regards to a question, I would ask you to raise your hand so Dennis can alert us. With that, I'll open for questions. Are there any questions? Representative Miller? Senator Pittman, welcome. And family. Who do you have with you? Who is it? Off with his head. Okay. Are there any questions? Representative Ralph.
Thank you, Mr. Chair. Actually, a couple of questions, and I think I'll deal with both witnesses if that's all right. But I think initially, Mr. Stafford, in regard to the public or the private health, protected health information piece of this. So what I think I understood from what you were describing is there's a concern about what we'll just say data collection groups apparently having contact with individuals, obtaining health information from them, and then passing that health information along to an attorney that they got directly from the person who had that information. Am I understanding that correctly?
Yes, that's correct. Because I think Mr. Silverman pointed out on the misleading front, somebody could think that they're dealing directly with a law firm based on what they're seeing on the television, making that phone call, and unbeknownst to them, their private information, what they think is their private information that they're sharing, is then being sold to somebody else.
Okay, and so I think that then goes back to my concern specifically in the drafting of this legislation is this legislation talks about the use of protected health information, defines it as defined under our statute, which a separate statute, which defines it as it's defined in HIPAA. And under HIPAA, protected health information specifically is defined as information that is, I lost the language here, is information that is obtained by covered entities. And those covered entities are specifically defined under HIPAA, and those in general sense are doctors, hospitals, or health insurance carriers. So the obtaining of information, just generally health information by a data center is not protected health information either under our statute as it's defined or under HIPAA as it's defined. So at least as I read Section 2, it's of no consequence and has no application because a data center is not a covered entity, and therefore any information they're obtaining is not protected health information as defined under our statute or under HIPAA. So I think I'm just making that at this point more as a statement for you and proponents to consider, because it looks to me like that section of the statute is doing nothing in relation to data collection centers. Unless you've got an answer right now, but I think it's more just a statement for consideration.
Sorry, I'm going back and forth between statute and
yeah, no problem.
The bill, Mr. Chairman.
Possibly Charles Reimer could answer that by putting the definition in here and saying that that's illegal. Would that qualify, or does the other statute override that?
So under section 2, subsection A, we're referencing, shall not sell without written authorization protected health information for the purpose of soliciting an individual. And then we have protected health information defined under HIPAA. So if Mr. Stafford has a HIPAA definitions right there, I haven't had an opportunity to look at those, but I guess the issue would be if the way that HIPAA defines protected health information, because in this bill, we're saying you can't use it in a certain specific way. You can't use it to solicit an individual for legal services. So if, there's a reference to that HIPAA only applies to certain entities. But the specific provisions of those of this bill may not be limited by that. So it would really depend on the specific language, I think, of, whether how HIPAA interacts with this bill.
Okay.
Well, yeah, and to that point, Mr. Chairman, Eric Stafford with the Kansas Chamber. Just searching here, protected health information includes diagnosis, treatment information, medical test results, prescription information, for example. So they can't sell that without the written authorization. So they're referring back to HIPAA on what's classified as protected health information.
Mr. Chair, if I might, at this
go ahead.
point, protected health information is the term given to health data created, received, stored, or transmitted by HIPAA-covered entities and their business associates in relation to the provision of healthcare operations, or payment. So again, under HIPAA, protected health information is a defined term, specifically applies only to, in essence, doctors, hospitals, health insurance providers. So if we want to define protected health information under our statute, then and reference it to HIPAA, then that's what it applies to at that point. So I don't want to belabor the point. At this stage, I think the proponents know what my concerns are there.
Look, it appears that the issue is that we're referencing the definition of HIPAA, which only includes the caregivers. And so we got to find a better way to do that if that's the intent.
If that's the intent, yes.
Okay. All right. You have another question?
Yeah, if I might follow up, one more question for our other proponent. Thank you, Mr. Stafford. Appreciate your testimony, sir. All the way through it looked like you were referencing to us several circumstances related to misleading commercials and deceptive practices. Is there anything of what you've described that is not covered either under our Kansas Consumer Protection Act or under the ethical constraints provided by our Kansas Bar Association that could not address any of the items that you've brought to us?
Sure. And just to backtrack on your previous question, I think that the intent is to expand the coverage of HIPAA to apply beyond the covered entities. And if some change needs to be made because of the way that the Kansas law is defining protected information, then maybe that needs to be done. But to your current question, I think first, with respect to whether the Kansas bar rules adequately regulate these types of ads, I think it's important to recognize that the bar rules only apply to Kansas attorneys to start. And a lot of these ads aren't run by Kansas attorneys. They're run by non-practicing attorneys outside of the state. They're run by lead generating companies, both within or with outside the state, and they can't be touched by regulation by the bar. But even if they could, even if it does involve Kansas attorneys, I think it's important to look at the wording of the bar rules, disciplinary rules, Rule 7.1, which I know some opponents might say that, oh, we've already got a rule that bars misleading information by attorneys. But that's actually not exactly what the rule says. It bars false or misleading communication about the lawyer or the lawyer's services. So what that really goes to is basically where you see it most frequently used is things like fee disputes. Did the attorney say that it's going to be completely free in the commercial and then they charge expenses? Those types of things that go directly to the lawyer or the lawyer's services. But when we're talking about public health information and the qualities of products and whether they're dangerous and these types of practices that we're talking about here, it doesn't involve the attorney or the attorney's services. You're not going to see people who see these ads on TV file a bar complaint. It's going to be the last thing they do. Does the consumer protection law, is it broad enough to take in these kinds of practices? Possibly. It does, the Kansas Consumer Protection Act has broadly prohibited unfair and deceptive practices, but it doesn't define in this context what those are. And I think this bill is helpful in doing that. And I think it also corrects the misperception sometimes that's the Bar Association, not the Attorney General or harm consumers that can use the Consumer Protection Act to address these types of practices.
Thank you, sir. Appreciate your testimony. Thank you, Mr. Chair.
Representative Probst.
Well, thank you, Chair. Representative Ralph kind of hit on my questions, but as we were talking about the protected health information, it struck me that I don't know how we address that if unless we do something that restricts my ability to freely share my health information. If we're going to use that definition and we're going to try to do in statute what we're trying to do here, you're effectively telling individuals that the information they share falls under this protected health information, which I have the right to tell anybody I want or not tell anybody what I want about my own health. And then also, I guess I would like an example or some explanation of, we talked a little bit about, my other question was about how we currently address this. And there are some code of conduct and kind of oversight on attorneys, but I'm struggling a little bit. We often talk in this committee about, free market and let things work out however they will. What other areas do we restrict advertising in? Are there other examples where we want to limit the ability to advertise?
I mean, Charles, if you want to answer that, I think you can probably do it.
Or the proponents, if they have that information.
Yeah. I think we limit, we have a lot of laws regarding how to advertise certain things, from tobacco all the way down to, from tobacco, liquor, false advertisement, false claims.
I guess that's the core of my question is, if we have that, why do we need additional protections on this? Why do we need a specific statute to address this?
Mr. Stafford.
Thank you, Mr. Chairman. Eric Stafford with the Kansas Chamber. Just quickly searching here. Food advertising and sales practices, misleading advertisements about vehicles. So yeah, there are regulations in place already today in various industries. I don't view this as an anti-free market. Let's go in order of questions. I think to your first point, you should be able to provide your information to whoever you want. We're not saying that you can't. We're just asking that company clarify and ask for written authorization from you in order for them to have your information. So we're not prohibiting that practice. We're just asking for written authorization from the individual before that takes place. To the second point about free market, I think that there's not one person in the legislature that would support allowing individuals to intentionally mislead consumers within our state, whether it's legal advertising or I mentioned food and vehicles. So I think that protecting consumers against misleading advertisements, not using the word recall if there has not been a recall. Listening to the oral arguments yesterday from the Court of Appeals on the West Virginia case, they discussed that, and they're not. Gosh dang it! I totally just lost my train of thought. Give me a second; it's going to come back to me. I'll think of it, and if it's later, I'll answer your question at the appropriate time. I'm sorry.
You get an email about 1:30 this morning.
Yeah.
I just have one more comment. If we're going to look at this and work this bill, I'd love to expand this to political content.
I believe that's already disclosed, Mr. Chairman, on the Kansas Ethics website.
Representative Clayton.
Thank you. And I'm not sure which of our proponents could speak to this, but could someone help walk me through the process of what it takes for a drug or a medical device to be recalled by the FDA? Either one of you.
I might defer to Mr. Silverman just to be certain.
Mr. Silverman, would you know that?
Sure, I can give some basic information. It's not an area I practice in, so. But there are different types of recalls at the FDA level. If we're talking about drugs and medical devices, you could have a recall that's voluntary. You could have a recall that is results from the inquiry by the FDA to the company that basically suggests that a recall is needed, or you could have an FDA ordered recall. So there's 3 different routes that can initiate a recall. But no matter which route is taken, even if it's a so-called voluntary recall, recalls are conducted along with the participation of the agency. The agency would look over basically a recall plan to make sure that it's adequate and sign off on it. And it would monitor the recall to make sure that it was effective. And no matter which of the 3 routes it goes, that would be part of the process. Hopefully that answers your question.
I guess if I may have one more follow-up, Mr. Chair. Thank you. Could we say how long on average or how many complaints or, issues could be listed? How many years would it take between, say, one, failed instance where you have injury or death based on a medical device or a drug? How long between that, first instance and a recall, or more importantly, how many times does that particular device or drug need to hurt? How many people get hurt on average before something is recalled, would you say?
I don't have an answer to that. I mean, I think a company could act very quickly if it wanted to. If it got information that there was a clear medical problem, they could recall a drug or device or whatever it is very quickly. How long it takes in all situations, I really don't know for sure. But I think it's just important to recognize that the bill that you have before you doesn't stop people from saying that there are safety concerns with a product if it hasn't been recalled. It just stops you from saying that a product's been recalled when it hasn't been recalled.
All right, thank you. And I think it's just, again, this might be better covered at the federal level. I'll certainly be asking our congressional representatives some of these questions. And just bear in mind that when you do hear these type of advertisements, it does give people pause before getting these types of medical devices or drugs. And so I feel from the standpoint of consumer protection that the recall thing is kind of where my sticking point is, because it does seem like it's difficult to get some things recalled. Thank you so much for all of the information you provided. Thank you, Mr. Chair.
Okay, seeing Representative Dotson.
Yeah, maybe Eric, you could answer this relatively quick. Thanks for putting this element in there about readability. We see so many of these advertisements that are in very small font, move across the screen so quickly there's no chance unless you took a picture of it. My assumption is that a lot of these advertisements are geared to people who are a bit older and may have some readability problems even with larger fonts. So I'm just wondering on a technical level whether we ought to specify font and speed as part of this readability issue so that you don't get into court and have to have an argument about this later. Thank you.
Mr. Stafford.
Thank you, Mr. Chairman. Eric Stafford with the Kansas Chamber. Yeah, and I had that pulled up here shortly, or a little while ago as I was reading through it. And I'm trying to find that provision. Clearly legible and if televised, displayed electronically, shall be displayed for sufficient time and enable the viewer to easily see and fully read the disclosure or disclaimer. Spoken disclosures shall be plainly audible and clearly intelligible. I think that, to Representative Dotson's point, I think we're comfortable with that compared to where we are today. And I guess we would leave it up to the will of the committee if there's something that that wants to be put in there. And following up too, I found here too that there are statutes in place, 65, 28, 36, that could result in the revocation or suspension of a license for a physician if they are false or misleading in their advertisements as well. Under existing Kansas law. So physicians are held to this standard in Kansas law today.
Thank you. Thanks, Mr. Chair.
Seeing no further questions, thanks everyone. We're going to move on to the proponent or the opponent section. And it looks like we're first up is Joseph Molina, Kansas Bar Association. Welcome to committee.
Good afternoon, everybody. Joe Molina with the Kansas Bar Association. We have a number of opponents to this, so I may leave some of the more technical issues to them. I haven't practiced personal injury or advertised in 20 some odd years, so it might not be my forte. But today I want to go ahead and talk about a couple of things. First of all, the Kansas Bar Association plays no enforcement role in legal advertising. That is for the Supreme Court. We also have the Disciplinary Administrator's Office, who actually speak about specific types of legal advertising that lawyers can and cannot do. Just like what Mr. Stafford just mentioned, where doctors are, excuse me, where doctors are held to a high standard for misleading advertising, so are lawyers. I believe that Section 65 may refer to the Board of Hearing Arts, whereas lawyers, we're governed by the Disciplinary Administrator's Office. So I just want to make that clear going forward. The Kansas Bar Association is here today because we're pretty interested in judicial independence. And when we start talking about having lawyers be subject to different types of rules, it gets a little confusing. We like to be subjected to the rules from the Supreme Court. That's what we do. That's our license. That's where they can take the most effective and immediate action. If you violate some of the rules of professional conduct, you can lose your license. That's a very big thing. And I believe there's only been a handful, less than a handful of lawyers who have ever been disbarred in the state of Kansas that ever got their license back. If you mess up in Kansas as a lawyer, you're pretty much done. And so we're going to take that very, very seriously. We want the judicial branch and the Supreme Court to make sure their rules are in place, they're effective, they're quick, and we have a specific set of rules that we can follow. I believe we have someone here today from the Board of Disciplinary Administrators who can speak to some of the rules that some of us lawyers have to actually go ahead and abide by when we're doing legal advertising. But when we speak to Senate Bill 150, I'd like to focus on two things. We heard people talk about the types of things that a lawyer under Senate Bill 150 cannot do. And we look at the specific text, right? They say that a lawyer cannot use the word recall, right? Unless it is performed by a governmental entity or is a agreement between the company and a governmental agency. I believe that's the language from the bill, which means there are instances where a recall could be legitimate. It could be truthful, but a lawyer could not use that. And if a lawyer did use that, they would then be in violation of Senate Bill 150. So basically, a lawyer could tell the truth in certain instances and be found to be deceptive and misleading under Senate Bill 150. And I actually looked it up this morning. We had in February a voluntary recall of a baby formula that was gone through to some of Kansas residents who use a specific type of baby formula. That is voluntary, right? It's not from a government entity. It didn't say it was from an agreement between the manufacturer and a government entity. It was just from this company saying, hey, maybe we don't use this. We're trying to look up why a couple kids got sick. 4 kids got sick. And if a lawyer put that into an advertising, he'd be in violation of Senate Bill 150. So we kind of have a problem with lawyers being able to tell the truth but being subject to penalties. Now, also, I want to focus a little bit farther down in Senate Bill 150 where they ask lawyers to be doctors. There is a specific statement that says, I should read it. I have it here. Excuse me one second. Do not stop taking a prescribed medication without first consulting your doctor. That is medical advice. Under the Kansas law, you cannot say that. And if you do say that, you're acting as a medical doctor. I believe the appropriate statute would be 65-2803. If you act in Kansas without a license, you're subject to penalties by the Board of Healing Arts. So this Senate Bill 150 compels lawyers to say something that would make them be in violation of the Board of Healing Arts regarding medical license. So we're going to have to take a look at that. And the last point I wanted to make before I actually let other people speak is this has been passed in a number of states, 3 or 4. Right? And one of those states, we actually have a Court of Appeals case going on right now. I listened to it myself. Why don't we just wait? We could wait. We could see what West Virginia decides to do with this case. It's very similar, if not identical language. Right? West Virginia right now is spending hundreds of thousands, millions of dollars. Kansas has jumped in the fold on these types of lawsuits in the past, and we got burned. We spent over $2 million defending a case that we had to pay to some outside counsel. We could just wait, have West Virginia spend their money for once, right? And then we can come back and maybe look at this thing after we find out. West Virginia could very well find it to be constitutional. We do not believe that to be the case. But if they do, we can come back and we can work on some of the other issues. The public health information point, for instance. And if we revisit this, this is not something that would automatically just go away. Or they could find it unconstitutional, and then we could all take a breath of relief and then move on to something else. So those are just the 3 other things I wanted to say. I'm happy to stand for questions at any time.
All right. Thank you very much. We're going to keep going on the opponents and then ask questions. Is Dustin Devon here?
Yes,
or
sir.
online?
On my train online.
Is there anyone else in person before we go online? Joe McGreevy? Dustin, hold please. We'll get to you.
Good afternoon. Thank you, Chair and Committee. My name is Joe McGreevy. I'm a Kansas licensed attorney. I run a solo practitioner's office in Kansas City, just down the street from KU Medical Center. So this bill would directly apply to me. I'm also a member of the Kansas Trial Lawyers Association, and I'm speaking today on their behalf as their conferee. We are speaking out today in opposition of this bill for the reasons set forth in my written testimony, but I'd like to address some of the questions to avoid being redundant. Representative, with respect to whether this is redundant of federal regulations and causes confusion with HIPAA, I would completely agree that once the information is provided to anyone who's not a doctor, you're going to have some serious concerns with how this interacts with HIPAA and whether or not that is in fact protected health information. As an attorney myself, if I get any of that kind of information, I have rules about how I can and cannot use that information under the professional rules of conduct that are already in place. That is one of the reasons this bill is redundant and unnecessary in the view of KTLA, is that there are several statutory provisions that already regulate how someone like me advertises. I have to state that I am responsible for my advertising. If you look on my website, it will say that it is paid for by McGreevy Law, LLC, and the responsible attorney is Joe McGreevy. If I violate any of those rules, I am subject to have my license revoked immediately, and that is a serious offense and a serious consequence, as Mr. Molina said. This law is also duplicative of Federal Trade Commission Act Sections 5A and 12A2 that also regulate deceptive communications, including for attorneys related to drug and device sales. So this is already covered at the federal level as well. If this is challenged, and it is likely to be challenged in Kansas, as it has been in many of the other states for some past. So, if we're looking at legal trends, there are 5 states that have tried to adopt similar language: Texas, West Virginia, Indiana, Louisiana, and Tennessee. It's been vetoed in Louisiana. In Indiana, it doesn't include attorneys. It's just the attorney advertisers, because attorneys are regulated by the Supreme Court under the Kansas Constitution. So this is also going to have to be addressed as whether or not it conflicts with the Kansas Constitution, as well as the First Amendment of the United States Constitution. And West Virginia has in fact held that, yes, it does violate the First Amendment. It does violate the U.S. Constitution, and not just at a strict scrutiny level because it impedes First Amendment speech, but at an intermediate scrutiny level, which is even lower. So when Mr. Molina brought up the point about waiting, it's actually a pretty good idea to see what a court of appeals actually applies as the appropriate test before we figure out what this bill is going to have to go through. Lastly, I would completely agree with Mr. Molina that I would be hesitant, and in fact, I don't know how I would have to take this advice, and if I had to say it, do not stop taking prescribed medication without first consulting your doctor is medical advice. As an attorney, I see that as medical advice. You know, I've never seen an ad that told someone to stop taking their prescribed medicine. I've never seen that ad. And as a plaintiff's attorney, if I saw that ad and someone were damaged by that, I would find a cause of action in existing law to pursue that advertisement. It would violate all sorts of laws that are already in place. So again, I will stand for questioning when the time is ready. But lastly, I would like to make one point on your question, Representative Dodson, regarding the legibility of some of the disclaimers. More often than seeing attorney ads, I see the ads for all the various drugs that you should ask your doctor about if you're sad or depressed or have high blood pressure, and then the laundry list of complications that come after that are spoken so fast that almost always include death, that they get through really quick. Are we going to have the exact same thing at the end of every attorney ad on, is that going to be legible and sufficient? This bill is unclear as to whether that would be sufficient. And so I think we're going to be left wondering, okay, was that ad actually deceptive? And now we're going to place that jurisdiction in the hands of the executive branch when the Kansas Constitution actually places that jurisdiction in the hands of the judicial branch. Thank you.
Is there anyone else in person that wants to testify in opposition? Seeing none, we'll go to the online.
Thank you, Mr. Chair. My name's Dustin Devon. Thank you for allowing me to testify today via remote. I do have a personal injury law firm that covers almost the entire state of Kansas. I do advertise on television. However, I do not have any national drug advertisements. So in theory, this law does not apply to me or my practice. I am here today to testify in opposition. And I have two primary points. I've taken good notes from what Mr. McNeely and what Mr. Moline testified about, and I will try my best not to repeat those things. The two primary points are first, that this is unconstitutional as a violation of free speech, and second, the law is unnecessary and duplicative, or just more government. Before I hit on the highlights in those two things, I do want to take issue with the Kansas Chamber's argument that attorney advertising causes companies to pay claims. And you can't get any further from the truth. In this country, we have evidentiary standards. We have a burden of proof that the person bringing the claim must sustain. And then we have a jury weighing the evidence and using the law that the judge provides. Only then does the drug manufacturer have a risk of having to pay a claim. And so attorney advertisements do not make companies pay claims. With respect to the unconstitutionality, as Mr. Moline's already indicated, a federal judge in West Virginia, which is an extremely conservative state, has already declared that legislation making it where they cannot have these advertisements. They essentially said that you cannot declare through legislation that certain words are misleading or unfair. The federal judge also stated that a state cannot justify a law's bans on advertising that contains truthful, factual, and verifiable information. Federal Judge Bailey was appointed by George Bush. So he's a conservative judge in a conservative jurisdiction. And he specifically held that this law in West Virginia that's identical to the one in Kansas, Senate Bill 150, was unconstitutional. I agree with Mr. Molina and Mr. McGreevy that passing this law now before the Fourth Circuit Court of Appeals can review this constitutionality makes no sense whatsoever. At the very least, we wait until this time next year to see how the Federal Circuit Court rules. One thing that was only touched on briefly is why is Senate Bill 150 unconstitutional? And if you study the briefs and the rulings of the court in that Fourth Circuit, there's essentially four very simple reasons. Number one, this act imposes a ban on the word recall, even when a recall has actually taken place, but in a method not covered by the act. And Mr. Moline hit on these two things. It does permit a recall if the recall is made by a government agency or through an agreement between the manufacturer and the government agency. However, there's two other scenarios that's not covered by this that still prevents the advertisers from using the word recall. The first is when there's a manufacturer voluntary recall in which the FDA takes no position. The second is when the FDA requests a recall, the manufacturer denies it, and it's brought before a court on an injunction order, and the court orders the recall. So under those two situations, there can be a actual recall, but it's still banned from the advertisement. A second reason this was held unconstitutional is it prohibits the use of a government logo to report accurately the stance the FDA or another governmental entity has taken. For example, displaying in the ad what the FDA's position is. The third reason that the court found was it prohibits the terms medical alert or health alert or consumer alert. Banning an attorney from having that in an advertisement is a violation of the commercial right to free speech. The fourth is the requirement that requires disclosures. This Senate Bill 150 requires disclosures at the beginning of an attorney advertisement. The U.S. Supreme Court back in 1970s already ruled that attorney advertisements are protected by the First Amendment. And fundamental to this, and is upheld in several different circuit courts in the federal level, is that attorneys have the rights to advertise, which includes the right to tailor the content of those ads. So the why behind all this is undue advertising restrictions reduce information available to consumers and defeat the purpose of the First Amendment. My second point was that the law is unnecessary and duplicative. As Mr. Molina hit on, we have the Kansas rules of professional conduct that already apply to Kansas attorneys. We have the state rules of professional conduct of all other states in the nation that apply to those attorneys. For non-attorneys that are making these ads, we have the Federal Trade Commission Act, and we also have the Consumer Protection Acts that protect consumers. Our model rules, and I believe that the disciplinary's office has submitted written testimony, but we have Rule 7.1 that defines or prohibits false and misleading communications. We've got 7.2 that gives specific guidance about advertising content, and 7.3 that requires advertising materials to be identified. It's policed by 8 members of the 8 attorneys in the disciplinary's office and a whole team of investigators. And so another law is not needed. I don't have any other arguments to make unless the committee has questions.
Representative Ralph, have a question?
Just if you're ready to take questions for the opponents.
Is there any, let's find out if there's anyone else here to testify online or in person. Seeing none. What? Okay, we're on opponents right now. Okay, thank you, though. All right, Representative Rao for the question.
Thank you, Mr. Chair. A couple of questions for Mr. Molina, if I could. And Paul, you're on your way up, sir. Appreciate your testimony. In looking at this bill, first off, with the first sentence, this bill applies to any Kansas attorney for any legal advertisement. As I read this, a person engaging in legal advertisement within this state shall, and then we list those. So this isn't, although we've talked about medical devices or pharmaceuticals, this applies to any advertising done by an attorney in the state of Kansas.
Yes, I know people said the intent was to focus on some lead generators or advertisers from out of state, but this affects KBA members, people who aren't the KBA members. If you're a lawyer in the state of Kansas, this will touch you.
So I'm specifically looking on the first page of the bill under section 1A and then item number 6, where we talk about all the shalls. And the shall in item number 6 talks about indicating the identity of the firm that will represent the clients. But then it goes on to say that, or how cases will be referred to attorneys or law firms and who those attorneys may be. Across the state and out in my neck of the woods, let's use me. If I've got a phone book advertisement where I say I take personal injury cases, and somebody walks in with 6 people involved in an accident involved with 3 trucks, and it's what we would call major litigation. They may walk into my office, but I'm certainly not taking that case, but I'm going to get them to somebody, refer that case along. As I read this particular legislation, my phone book advertisement saying I just do personal injury would not comply with this statute, because I'm not making reference, as it requires me to who I might or will refer cases out. And that would be whether it's car accidents or major trust cases or large wills or tax questions or anything else. If I have to refer, or I'm going to refer those cases out, it makes me identify who those attorneys are right out of the chute before I can ever submit that advertisement.
Before you even know who could be actually involved in those types of cases. And this touches on the Kansas Bar Association specifically, because we have a lawyer referral service. We have individuals that will call into the KBA wanting legal advice, and if that fits that situation where it's a multiple type plaintiffs, we would have to actually be subject to Senate Bill 150.
Thank you, sir. That's all I have, Mr. Chair.
Any further questions for the opponents? Mr. Molina, while you're there, you had mentioned legal advertising that a lawyer can and cannot do is kind of monitored by the Supreme Court.
Yes, sir.
What about these? I think this bill is also, or the main target, I think, are these lead generation companies that are not attorneys. Does the Supreme Court have any authority over them other than if a case gets to them for not lawyers?
If they're not lawyers, no.
Okay.
Not for the legal advertising part. I think the Kansas Consumer Protection would. In a past life, I actually was a assistant attorney general specifically for the Kansas Consumer Protection Act. I think I did 15, 20 types of these types of deceptive, unconscionable claims. And we did look at some of those out-of-state actors because that's a little bit more effective, to be totally honest. And we have a hammer at the Kansas Consumer Protection Act for out-of-state types of people, which would make this kind of duplicative when you can use the bigger hammer of $10,000 per violation. And I would focus on having the Attorney General look at those out-of-state types of things and not create new legislation.
Okay, thank you. Any other questions? Seeing none, we'll move on to our neutral testimony. Thank you, sir. And that is Matthew Vogelsberg. Is that correct? All right.
Good afternoon, Chairman Tarwater, members of the committee. My name is Matt Vogelsberg. I work for the Office of the Disciplinary Administrator. That's an agency within the judicial branch that is charged with investigating and prosecuting claims of attorney misconduct. I'm here this afternoon to present neutral testimony on Senate Bill 150. In the short time that I have to speak with all of you, I want to go over 2 main topics. First, I want to give you an overview of how attorney advertising and other communications regarding legal services are currently regulated under the Kansas Rules of Professional Conduct, or KRPCs for short. Second, I wanted to discuss the overlap between the requirements found in the KRPCs and in Senate Bill 150 and discuss the provisions of Senate Bill 150 that were recently found to be in violation of the First Amendment by the Federal District Court for the Northern District of West Virginia. That decision is noted on page 5 of my office's written testimony. As noted on page 2 of the written testimony, KRPC 7.1 through 7.5 regulate communications about legal services. 7.1 commands that in general, a lawyer shall not make a false or misleading communication about the lawyer or the lawyer's services. The rule goes on to state that a communication is false or misleading if, among other things, the communication contains material misrepresentation of fact or law or omits a fact necessary to make the statement considered as a whole not materially misleading. I would also add that KRPC 8.4C prohibits a lawyer from engaging in conduct involving dishonesty, fraud, deceit, or misrepresentation. So an attorney who engages in false or misleading advertising would be violating not only 7.1, but 8.4C as well. For purposes applying the KRPCs, attorney communications are placed into 2 general categories: advertisements and solicitations. Advertisements are communications directed to the general public, such as through a billboard, a website, or a television or radio commercial which advertises the lawyer's services. In contrast, a solicitation is a targeted communication initiated by the lawyer that is directed to a specific person and that offers to provide legal services in exchange for compensation. Different rules apply depending on the communication at issue. If the communication is an advertisement conveyed to the public at large, then in addition to the general requirements that the advertisement not contain any false or misleading information, KRPC 7.2 requires that the advertisement contain the name of at least one lawyer responsible for the advertisement's content and requires that a copy or recording of the advertisement be kept for 2 years after its last dissemination, along with a record of when and where the advertisement was used. If the communication is a solicitation, again, a communication initiated by the lawyer that's directed to a specific person offering to provide legal services in exchange for compensation, then KRPC 7.3 applies. 7.3 bars a lawyer from soliciting a prospective client by using in-person, live telephone, or real-time electronic contact. In other words, a lawyer can't approach a stranger on the street or call a stranger on the phone and offer to provide legal services in exchange for compensation. 7.3 does allow lawyers to solicit employment from potential clients by using written, recorded, or electronic communications that don't involve real-time contact, such as an email. However, if the person targeted by the solicitation has made known to the lawyer that he or she does not want to be solicited, the lawyer must end further attempts to solicit the person for employment. And regardless of the means a lawyer uses to solicit a client, all solicitations can't involve coercion, duress, or harassment, nor can they be false or misleading. Finally, every written, recorded, or electronic communication from a lawyer soliciting employment must include the words advertising materials. In contrast to the KRPCs, Senate Bill 150 does not distinguish between communications constituting advertisements and communications constituting solicitations. Both types of communications are considered legal advertisements, as that term is defined in Senate Bill 150, and are regulated in the same manner. Senate Bill 150 prohibits 3 types of contents from a legal advertisement. First, the bill prohibits a legal advertisement from being presented as a medical alert, health alert, consumer alert, public service announcement, or similar terms. Under the KRPCs, it's possible that this conduct would be considered misleading under 7.1 or 8.4C, and if the communication at issue was a solicitation, it's possible that presenting the solicitation as a medical alert or similar term would constitute using coercion or duress, which is prohibited under 7.3. Second, Senate Bill 150 prohibits a legal advertisement from displaying the logo of a federal or state governmental agency in a manner that suggests affiliation with or the sponsorship of that agency. The Office of Disciplinary Administrator believes that this type of conduct is already prohibited by KRPC 7.1 and 8.4C. Third, Senate Bill 150 prohibits a legal advertisement from using the word recall when referring to a product that has not been recalled by a governmental agency or through an agreement between a manufacturer and a governmental agency. KRPC 7.1 and 8.4C would be violated if an advertisement or solicitation stated or suggested that a product had been recalled when in fact it had not been. Notably, it appears that Senate Bill 150 would make it illegal for a legal advertisement to truthfully inform the public that a manufacturer had voluntarily recalled a product without government involvement. For this reason, the Federal District Court in the Northern District of West Virginia found this exact provision in a similar bill to be unconstitutional. Senate Bill 150 also requires communications regarding legal services to contain 4 disclosures. First, all communications advertising legal services must disclose at the outset that it is a paid advertisement for legal services. As previously mentioned, KRP 7.3 already requires solicitations, i.e. communications targeted to specific people, to be identified as advertising material. But communications targeted to the public at large, like billboards or TV commercials, are not required to specifically be identified as advertising materials. Second, Senate Bill 150 requires all communications advertising legal services to indicate the identity of the attorney, law firm, or other sponsor of the advertisement. As previously mentioned, KRPC 7.2 requires that all attorney advertisements, again, communications targeted to the public at large, must include the names of at least one lawyer responsible for its content. KRPC 7.3 does not require solicitations to identify the lawyer responsible for its content. Third, Senate Bill 150 requires that if a legal advertisement is targeting individuals who may allege an injury from an FDA-approved drug, the advertisement must include the following warning. Do not stop taking a prescribed medication without first consulting with your doctor. Discontinuing a prescribed medication without your doctor's advice can result in injury. This disclosure is not required under the KRPCs, and it should be noted that the court in the Northern District of West Virginia found this exact disclosure to be in violation of the First Amendment because the disclosure constituted compelled commercial speech, which was not purely factual. The court reasoned that the disclosure constituted medical advice or direction and not a verifiable statement of fact that would be true in every instance. Finally, Senate Bill 150 requires that if a legal advertisement is targeting individuals who may allege an injury from an FDA-approved drug or medical device, the advertisement must disclose that the drug or medical device remains approved by the FDA unless the product has been recalled or withdrawn. This disclosure is not required under the KRPCs, and the court in the Northern District of West Virginia reasoned that the disclosure violated the First Amendment because whether the compelled disclosure should be given was a subject of controversy, given that opioids remain approved by the FDA despite the current opioid crisis. I hope my testimony today has given you some insight into how attorney advertisements and solicitations are regulated under the KRPCs, how the KRPC's requirements are reflected in Senate Bill 150, and how some of Senate Bill 150's provisions have recently been found to be unconstitutional by the court in the Northern District of West Virginia. Again, thank you for allowing me to testify today. I'd be happy to answer any of your questions at the appropriate time.
Are there any other neutrals in the House? Okay. Seeing none, any questions? I've got one. Somebody at home.
I apologize, Mr. Chair. For some reason, WebEx decided to unmute everyone randomly. So my apologies.
Well, we've been having quite a few computer program issues today, haven't we, Cindy? Does your agency deal with individuals or just attorneys?
We deal with attorneys that are licensed in Kansas, also attorneys who have been admitted pro hoc vice into Kansas as well. It means basically an out-of-state attorney who associates themselves with a licensed Kansas attorney for purposes of being able to litigate a case in Kansas.
So a lead generation company, would you have any jurisdiction over them if they were just advertising to get leads to sell to a
Not
lawyer?
directly,
Okay.
but indirectly. An attorney under KRPC 8.4A is responsible if they engage a non-attorney to do something that is in violation of the Kansas Rules of Professional Conduct. And so if an attorney in Kansas hired a lead generation service that violated KRPC 7.1, 7.2, 7.3, they themselves would be in violation of those rules.
But if they just bought these leads, they wouldn't be in trouble if they just received a bulk of leads that were generated by an ad that they weren't involved in.
If they knew that they had been generated in violation of the KRPCs, they could be in trouble. If they had no knowledge of that, then it would be difficult. Obviously,
Yeah.
couldn't prove a violation.
Is there a question down there? Representative Miller?
Thank you, Mr. Chairman. First, I want to say, in response to some earlier testimony, some of the most conservative friends of mine are some of the biggest protectors of the First Amendment. The inference was that somehow a conservative state or judge was it would be unusual for them to be a protector of the First Amendment. And I find that to be just the opposite with a lot of very conservative people. Sir, I wish the people around this table could have some of the instruction that I've had in my continuing legal education relative to those rules relating to advertising, and see some of the ads that are generated from outside of Kansas compared to those that are done by Kansas attorneys. I think they'd have a greater appreciation for our Kansas bar and the tactful, for the most part, way that we advertise in this state. My question for you, do you have any data as it relates to complaints your office receives relative to those rules regarding advertising?
Sure. I would direct the committee's attention to page 4 of the written testimony. It shows that between fiscal year 2017 to fiscal year 2022, knowing that is not over yet, that we've received a total of 5,338 complaints. And from those complaints, we have concluded 8 violations of KRPC 7.1 through 7.5. And so as far as areas of concern that my office addresses when we're receiving complaints, attorney advertisement is generally not high as far as generating complaints to our office.
And of those 8, do you have any record of the consequence of the discipline?
I don't have that in front of me. I'm sorry.
Okay. Thank you. Thank you, Mr. Chairman.
Any further questions? Okay, seeing none, thank you so much for coming today. Appreciate all the wealth of information. Committee, with that, we're going to go ahead. Well, we're going to draw your attention to the written testimony. You've got, I think, 4 of those that are that were sent to you today. And if you wanted to do any more research on this topic after today, I would suggest reading John Grissom's The King of Torts. It addresses this type of lead generation type stuff. And it's actually a pretty good read. I've read it twice. We're going to go ahead and close the hearing on SB 150 at this point, and I'll announce that tomorrow we are going to be having a brief rehearing on HB 2731. That's the smash and grab type bill that Representative Miller attempted to help clean up so that we can get a better grasp on things. And we're going to have just a few minutes of testimony, one from each side. And then that's going to be it. So after that, we're going to address the Promise Act in the contents of SB 340, and we're going to treat that as kind of a courtesy hearing. We're going to go through it as if it was a hearing. We're expecting that bill to come over at some point, or at least show up in some sort of a report. We expect it to come to us in some form or a matter, and I want the committee to be able to weigh in on it. So 2731, and that's in our committee. And then SB 340 is not in our committee. It's still over in the Senate. But there are some issues with the Promise Act that need to be addressed, and I just want to get those out in the open so that when it comes over, we can make a good decision. Representative Miller.
Procedural question. Did we make a formal tabling of 2731?
2731 is a number that was assigned to the bill that you.
That's the replacement
That's
number?
the replacement
Okay,
one.
thank you.
With that, we're adjourned. Thank you very much. And Eli, thanks for hanging out with us today.